Hi, I am Jason Kerel Valderrama, your reporter for this day. In this day, I will discuss the three chapters of the lesson. Chapter 1, General Consideration. Chapter 2, Survey of existing laws providing of alternative modes of dispute resolution. And the last, Chapter 3, the Alternative Dispute Resolution. So now, as we start, just stay, feel comfortable, listen, and relax. And now, let's start the discussion. Hi! So, let's start that. So, sa discussion po natin ngayon, magsisimula po tayo sa history of law. So, what is the history of law? In history of law, although the Philippine justice system may not be the replete with cases deal with the alternative dispute resolution. It nonetheless initially found its way in the Spanish Civil Code and later on enriched in the Philippine Civil Code. In 1953, Republic Act No. 876 gave the country its first arbitration law that regulated arbitration in general and is it still good law even at the present. In March in 2003, during the third regular session of the 12th Congress, Senate Bill number 2671, which proposed the institution of the alternative dispute resolution system in the Philippines, was deliberated upon in the 4th committee hearing on March 26, June 2, July 9, and July 16 of 2003. On November 12, the measures was assigned for consideration by special order in the Senate with Senator Pangilinan and De Castro delivering their respective sponsorship speeches the period of interpellation. Thereafter followed. On 14 of January 2004, the period of interpellations was closed and the period of committee and individual amendments followed. Finally, on 4 of February 2004, the measure of approved by Congress before it went to recess in preparation for the May 2004 national elections. So yun po, doon po nagsimula po yung history of law natin. Marami po siyang pinagdaanan, nagmula pa noong 1953 na pagsimula noon hanggang na-implement po siya at naging success po siya or na-implement po talaga siya noong February 4, 2004 ng sabay sa pag-prepare nila sa national election. The Chapter 1, General Considerations. The bill was finally signed into law by Her Excellency President Gloria Macapagal Arroyo in signing ceremonies at Malacanang Palace on 2 April 2004. Negotiation. Negotiation involves the parties to dispute. Through this method, both parties each present their position as well as examining the position of the other party. As the practice grew, two schools of thought emerged, each presenting its own theory on the dynamic of negotiation. First, theory is called competitive negotiations, and second, theory is called collaborative negotiations. Arbitration. It is derived from the Latin word arbitratio. In practice, it is the investigation of determination of an issue of difference between contending parties by one or more unofficial persons, chooses by said parties, and were called either arbitrators or referees. The ADR law defined it as a voluntary dispute resolution process in which one or more arbitrators appointed in accordance excuse me, with the agreement of the parties or rules promulgate pursuant to this act. Resolve a dispute by rendering an award. The arbitration have two takes on two forms: the compulsory arbitration and the voluntary arbitration. The compulsory arbitration the compulsory arbitration enforced through statutory provisions such as in labor-related case, while the voluntary arbitration proceed from the mutual consent of the both parties, usually in pursuance to an agreement prepared. Conciliation. Under Section 7 of the ADR law, the term mediation shall include conciliation. Those for purpose of the ADR law, conciliation is part of the mediation process. Mini trial. This refers to a private, voluntary, informal form of dispute resolution in which attorneys for each disputant make a brief presentation of his or her best cases before officials for each side who have authority to settle. The next is the Chapter 2, Survey of Existing Law providing for alternative modes of dispute resolution. Civil Code Provisions. The Philippine Civil Code provides for the submissions of a dispute or arbitration. The pertinent provisions are as follows: Article 2042, Article 2043, Article 2044, Article 2029, Article 2030, Article 2031, Article 2032, Article 2033, and the last is the Article 2034. The Civil Code Provisions. Article 2035, no compromise upon the following: the civil status of a person, the validity of a marriage or a legal separation, any ground of legal separation, future support, the jurisdiction of courts, future legitimate. In the Article of 20036, Article 2037, Article 2038, Article 2039, Article 2045, and Article 2046. Labor dispute. The Labor Code of the Philippines, the Article 260 of the Labor Code of the Philippines expressly provides that it is the duty of the parties to a collective bargain agreement to establish grievance machinery for the adjustment and resolution of the grievances. Katarungang Pambarangay. The Local Government Code, Section 399 to 422 of the Local Government Code institutionalized the Katarungang Pambarangay through the Constitution of the Lupong Tagapamayapa, loosely translated as a peacekeeping committee. Such lupon shall be constituted in every barangay throughout of the Philippines with the sole function to settle dispute arising between members of the barangay. Indigenous Cultural Committees. In 1987, Philippine Constitution formally recognized the existence of indigenous cultural communities, declaring it as state policy of promotion of their rights within the framework of the national unity and development. This policy should also be cross-referenced with the United Nations Draft Declaration of the Rights of the Indigenous People and ILO Conversation number 169. Commercial arbitration. In today's modern business environment, most corporations in dealing with other corporate entities provide for an arbitration clause in their contracts. Construction industry. Executive Order number 1008 In 4 February 1985, the President Ferdinand Marcos issued Executive Order Number 1008 creating an arbitration machinery in the construction industry of the Philippines pursuant to the declared state policy to encourage early and expeditious settlement of disputes. The Alternative Dispute Resolution Act of 2004 or the Chapter 3. So, nandito na tayo sa last part. Nakikinig ko po ba kayo? So, bago po kayo antukin, so, magpapatuloy na ako. Part of this law, the President has also certified the measure increasing the compensation of judges and justices. Thus, it can be said that these twin measures form the point in the government effort to address to a significant extent some of the concerns that have plagued and justice system delayed and lack of judges. Second, declaration of policy. It is hereby declared the policy of the state to actively promote party autonomy in the resolution of dispute or the freedom of the parties to make their own arrangement to resolve their disputes. Second, Sec 3 definition of terms. Alternative Dispute Resolution System, ADR provider, authentic arbitration, arbitrator, award, commercial arbitration, confidential information, convent award, convention stage. Court annex mediation, court referred mediation, early neutral evolution, government agency, international party, mediation party, mediation arbitration, mini trial, model law, New York Convention, non-convention award, non-convention state, non-party participant, proceeding means a judicial administrative record means an information written on a single medium. Rooster means a list of persons qualified to provide ADR services. Section 4, Electronic Signature in Global and E-Commerce Act. The provision of the Electronic Signature in Global and Economic Act and its implementing rules and regulations shall apply to proceedings contemplated in this Act. Section 5, Liability of ADR Providers Practitioners. The ADR providers and practitioners shall have the same civil liability of acts done in the performance of their duties. Three grounds for civil liability: bad faith, malice, and gross negligence. Section 6. Exception of the application of this Act. The provision of this Act shall not apply to resolution of or settlement section. Section 6 of the law provides for an enumeration of disputes that cannot be subjective to any settlement. Labor dispute, civil status of a person, validity of marriage, any ground of legal separation, future legitimate, jurisdiction of court, and criminal liability. Labor. Under the Labor Code of the Philippines, it is the policy of the state to promote collective bargaining, voluntary modes of settling labor disputes, free trade, unionism, a strong and united labor movement, enlightenment of worker, civil status, marriage, legal separation, and legitimate. Under the Family Code of the Philippine, marriage is a special contract in which the state has a special interest. Jurisdiction of courts. Jurisdiction is the authority by which judicial officers take cognizance of and decide causes, the power to hear and determine a cause, criminal liability. There is no longer any need to elucidate on this particular aspect regarding criminal liability. Article 2035 number no compromise upon the following questions shall be valid. First, labor dispute, civil status of persons, validity of marriage, future support, any ground of legal separation, and future legitimate. So now, and that's all, and thank you, and I hope you listen and relax. Thank you.